Matt Day here with Parsons, Graham and Day. I have an issue that comes up regularly, and I would say weekly, and that is, can children pick with whom they want to reside? There's not really an easy answer to that question, all right? If they're of a certain age, 12 in Oklahoma, they have a presumption that they could state a preference, and the court would be required to take that preference into consideration. Now, it's just a preference. It isn't binding on the court, although a lot of courts tend to follow the child's preference if that becomes an issue, especially if the child is an older child, 17, 16, 15, right? So they can state a preference. Do they get to just determine where they want to go? Not really. Now, there are some cases where the parents, by virtue of agreement or by virtue of their conduct, have essentially handed the keys to the kingdom to these kids, right? Their brains aren't fully developed, but we're letting them pick where they're going to stay and how long they're going to stay there and things of that nature. And so sometimes by virtue of the facts or by virtue of the conduct, the kid ends up being able to pick, right? But in terms of statutorily, no, it's stating of a preference, right? And the statutes also state that when it's feasible, we want to try and give each parent as much time as we can. So that indicates we want to try and equalize time, all right? But 12 and up, they get to state a preference. It's not binding on the court, although a lot of times courts do follow that preference.
The purpose of this video is to be informative and not to provide legal advice. For legal advice, call a law firm and speak to an attorney about your particular case. None of the information provided in here is meant to establish the attorney-client relationship between Parsons, Graham and Day and anyone watching this video.